Well, welcome back to Judicial Ways of Working, the podcast series produced by the Institute of Advanced Legal Studies at the University of London. My name is Carl Stychin, and I'm the director of the Institute. This series explores how members of the judiciary are working during the global coronavirus pandemic. I'm delighted to welcome to today's podcast two members of the Alberta Court of Queen's Bench in Calgary, Canada. Madam Justice Charlene Anderson was appointed to the court in 2013. Previously, she was in practice as corporate counsel, general counsel at the University of Calgary, senior enforcement counsel with the Alberta Securities Commission, as well as in private practice. She's joined today by Madam Justice Kristine Eidsvik, who was appointed to the court in 2007. Her previous career was in private practice, specializing in general litigation, insurance law, personal injury law, product liability, professional malpractice, intellectual property law, and language rights. Madam Justice Eidsvik is the judicial representative on her court's IT committee, and in that capacity, she's been actively involved in developments in relation to remote judicial working. And welcome both of you to today's podcast.
Thank you.
Charlene, let's start with you. Just to get us started, could you describe to our listeners your everyday professional life as a judge before the pandemic? What was
Yes.
it like?
So Justice Eidsvik and I are members of the Superior Court in Alberta, the Court of Queen's Bench. We are appointed and based in Calgary, Alberta, but we circuit throughout the province. Our day-to-day judicial functions change from, day-to-day or weekly. We can spend a day hearing a number of 15-minute applications to conducting judicial mediation to presiding over jury trials. So our days vary significantly. In terms of the types of cases we hear, we're a generalist court, so we hear family matters, civil matters, and criminal matters. In family matters, we have jurisdiction over divorces and matrimonial property division. We hear a number of child custody and access disputes, child support disputes, and spousal support. In civil litigation, we have jurisdiction over any civil dispute involving claims over $50,000. We hear a number of commercial matters, bankruptcy, insolvencies, wills and estates litigation, personal injury, judicial review. We also hear appeals from provincial court and appeals from masters, who are judicial officers presiding over procedural matters mostly. In criminal matters, we have jurisdiction over all indictable offenses. Our court tends to hear the more serious offenses, and of course the jury trials. Those trials involve murder, manslaughter, drug trafficking, any criminal organization offenses, the more serious sexual assault cases.
And just a follow-up for you, Charlene. To what extent was your judicial role previously enabled by technology? How much had remote working entered into your working life?
Well, our courtroom is relatively new. Our courthouse is 13 years old, so at the time it was state of the art. We're a court of record, so all of our proceedings are recorded by a central recording system. We do have CCTV or video conferencing for some matters. Perhaps if an accused is in custody and doesn't want to attend court for a brief matter such as a bail review, or where a witness may be vulnerable in a sexual assault case, for example, that we had the ability then to have them appear and testify remotely. But, sorry, I've just lost this. But there, I hope that gets edited out. But our rules of court allow for electronic hearings, but for the most part, we are a traditional court. We have most of our documents are paper filed. We have a principle that evidence and matters should be heard in a courtroom, and we're resistant to cameras in the courtroom. Very few allow cameras in the courtroom, and so to a large extent, we're very traditional. Justice Abella had an article in the Globe and Mail this weekend about how traditional our courts are and how we have to change. And she had stated that any lawyer from the 1900s would be very comfortable in our courtroom today. And that applies in Alberta and in Calgary.
Right. Yeah. Well, Chris, turning to you, you've been actively involved in the development of IT for your court. Could you tell us about the developments that had been taking place in Alberta before the pandemic in terms of remote working?
Sure. I thought I would start by saying that our Chief Justice, Chief Justice Mary Morrow, has been very pro trying to modernize our court in a technological way. And so with her leadership, she created and actually there had been started a technology committee for the Court of Queen's Bench. And I have been the chair of that committee, along with the co-chair in Edmonton for the last 6 years or so. And so in that committee, I was thinking about really where we started. We started by considering security concerns, because we all got computers. We were doing, we had our research done on computers, that kind of stuff. So, and we did emails, but that was basically our level of technology. The technology committee over the last 6 years has worked on things like websites, internal and external. Those were big projects to try to increase communication. We put in a digital scheduling system, which was huge. It sounds kind of silly, but before it was all done by hand, and we have about 100 judges, Court of Queen's judges that travel the country, countryside. So that's been a huge thing. In fact, that process started about 3 years ago, and we finally finished putting it in just last December. It gives us a huge amount of data too as to what's actually being heard or not. We've increased the education of judges on computers, but that has been slow. Some are quite willing to use their computers to do everything from writing judgments to creating documents and that kind of thing, but many are still handwriting their judgments and really weren't interested. I would constantly, as the chair of the technology committee, would get, well, I'm not a secretary, I'm a judge type of attitude. So, and that's what you sort of live with. And it wouldn't necessarily be by age. Surprisingly, some senior judges who have even retired now were very technologically competent, and some junior judges that have come up to me and tell me how much they love their paper. So anyways, what we tried to do, I had a sabbatical in 2017 and 2018, and I wrote a paper or report called Tomorrow's Court of Queen's Bench of Alberta, How Technology Can Transform It. That has been used across Canada. It sort of set out a set of priorities of how we can really move our court into the next, perhaps. Since then, we have made some progress since pre-pandemic. For instance, all our computers were upgraded. We had been working with very old computers. They hadn't been upgraded. So we have now, and I'm using right now, a nice Dell touchscreen computer. The e-filing and digital management system has been studied, but it hadn't been put into place. Virtual courts were really not happening. We would hear, as Charlene mentioned, we would hear some witnesses. We would hear witnesses from, for instance, from time to time for bail hearings, that kind of thing. But we were looking at, a lot trying to move forward, but the challenges were a couple. One is the Court of Queen's Bench doesn't manage its technology. The technology is managed by the government of Alberta. And so we have a memorandum of understanding with them that they are to take our considerations into account, but quite frankly, they're the ones that make the decisions. They're the ones that have the budget to do anything. So it's been difficult getting our priorities as judges considered. And in any event, in the last few years, there's no doubt you're aware, with the oil and gas prices being what they've been, Alberta has had fiscal challenges. So money towards technology in the courts has not been a high priority. Funding and procurement issues are also have been difficult. So even when we identify good software that we wanted to put in, we were having huge procurement issues, up to 2 years just to go through the government procurement process. So those are some of the challenges, and that's sort of where we were pre-pandemic.
And that's really interesting, and it does lead into the next question for you, Chris, which is, how has your work on technology accelerated as a result of the pandemic?
Yeah.
Necessity can make things move more quickly. Has that been the case?
That's right. Well, as the saying goes, never let a crisis go to waste. And so our court, as many courts across Canada, have not been letting this tragic pandemic go to waste. And it's amazing what has happened. I mean, initially, when the pandemic hit, our courts basically shut down. We realized that we had way too many people that couldn't be socially distanced in chambers and in trials and jury matters. It just was not possible to keep our courts open except for the most urgent matters. And so we really shut down to basically one courtroom. It's a large courtroom at the Court of Queen's Bench, and in Calgary. We shut down, we have 13 courthouses across Alberta. We shut down all but 4. And so Edmonton, Calgary, Red Deer, and Lethbridge are the only courts open at all, urgent matters. And then slowly we started adding virtual capability. That virtual capability has opened up the courts to a certain extent. And so now we're doing mediations virtually. I did my first one, I think the first one for the court on Tuesday. We're doing pretrial conferences. We're using teleconferencing a lot. I think pretrial conferences for the most part are by teleconference. I've been hearing commercial matters virtually. And what's happened, I've sort of set it out in different levels. Sort of the government level, what happened is that all of a sudden, procurement rules, I don't know what happened to them because I haven't been involved intimately. This has happened at the government level. The use of WebEx as our video conferencing software, and I don't know what happened to the 2-year slowdown in procurement, but all of a sudden we have WebEx, and that the video conferencing software has changed our lives because now that can connect into our recording system in the courtrooms. So now we have virtual courtrooms. We have several now that are open. And so we're hearing applications and it can be recorded in our digital recording system. And more importantly, we can now do these virtual hearings from home. So I did this mediation from my home here in Banff. And we're being encouraged to do these virtual hearings from home. So that's a a huge leap. We never did this before. The second thing I think is the judge level. The judges all of a sudden are enthusiastic. Many judges that I have always, I wouldn't say problems with. I mean, everybody has their own level of comfort with technology, but the ones that were not comfortable, all of a sudden were open to and enthusiastic to learn how to connect into the court systems at home, and have been involved in training. So the other day we had a court communication from our Chief Justice. We had 79 judges that joined in by WebEx. That's extraordinary to me. So that enthusiasm for training and to, they see the need and the requirements to the public to allow these hearings. So that's tremendous. The other thing is systemically, it's been a sea change in terms of lawyers. Like I've been pushing, as probably you can understand, being head of technology, digital documents being used for e-trials, for applications and commercial matters, which are very document intensive. But lawyers, they'll send over the stuff digitally, and then they come in with their boxes of documents, and I'll say to them, like, you're not going to learn how to manage these digital documents if you just continue to use paper. Now, guess what? The profession has changed. They're actually out doing virtual hearings by themselves. They're using all kinds of platforms like the one we're on now, Zoom, Skype, what are some of the other ones? WebEx. Anyways, it's everybody is using it, and all of a sudden the lawyers as well as the judges are moving. On the administration level, there's been a huge change. Now all of a sudden they'll accept email files. Electronic signatures are being accepted. Never had that happened before. Scanning is being allowed of huge amounts of documents. So we're now doing electronic divorce work, probate, adoptions remotely. And assistants are allowed to work from home. So we're connected in with our assistants. They've never been allowed to do that. And finally, today, I understand there's a test going on about a new e-filing system. Now, this e-filing, I've been pushing for years, and they're actually trying something out today. So these are all, it's shocking, frankly. And it just shows how, with willingness and effort, and, judges tend to be very concerned about the public. We might not have, and they understand that we need to continue to deliver justice. And it can't just happen in the courtroom. It's too dangerous. So, at all levels, people are really moving to virtual remote justice. Quite amazing.
Great. That's fascinating and remarkable, the speed at which it seems to be happening. Question to you, Charlene. So now those are all the developments that are happening. How are you managing the new reality of judging remotely? And are there aspects that you find particularly challenging, first of all?
Yeah, well, we have a small group of judges who are actually still going in physically into the courthouse to hear emergency matters. So I'm part of that small group. So I've done less remote work than Chris would have. But for me, the only thing that's changed really is, as Chris said, we're sitting in larger courtrooms so that people can distance. And our duty counsel now is attending by telephone rather than personally. And we're also much more flexible, obviously, in having the parties attend by remotely, either by video conference or telephone. I haven't done as much as some of my colleagues. I have conducted a couple of pretrial conferences by telephone. I've received briefs and orders electronically. The challenge for me, I think, would be in making sure, because we are a court of record, that when you are conducting something on telephone, that it is being recorded and it's being clearly recorded. And so that means you can't speak over top of each other, and you have to be much more careful and concise in your speaking.
And are there aspects of remote working that are there things you would quite like about this whole modernization agenda?
For me, probably the most exciting aspect of this will be the electronic filing. As you can imagine, when parties appear before you in court and you're given the court file, frequently orders are not there, or there's decisions or filings are missing. And so the thought of having that all done electronically and taking my laptop in is very exciting for me. And as well as being able to more easily find the documents that the parties are referring to. One of the challenges is I've learned I need more than one screen. It's difficult when you're looking at documents and trying to figure out, going back and forth. So there's been some challenges, but I think I can adapt.
Great. Back to you, Chris. In your work on the technology committee, are there aspects of these developments that give you cause for concern? And I'm wondering how you try to manage those.
Well, some of them Charlene has already mentioned, but managing digital documents now is a big concern. We don't have really the type of software that we could have, even though I'm pushing to get it. In fact, they have it in the UK. A lot of the courts, especially the Crown courts, are usually using a really top-end software product that I've been trying to get in place, and we'll see. But in the meantime, we're managing digital documents all over the place, and that's difficult. Having several screens, which I do have, both here and in my office, helps. Learning to manage remote hearings and mediations is a different technique. You have to use slightly different skills over a computer as opposed to in a courtroom setting. It's just a completely different setting. So I think that's going to be a new skill that we'll have to, learn as we do more and more of these. One of the things that comes up in some of the writings and I make an effort to show is managing the solemnity of the proceedings, because we're not dealing with things that are, very humorous for the most part. These are serious issues. We're acting in a serious way. I've noticed that some courts, like in Texas, in the background of a hearing, will have put in virtual backgrounds that have their flags and insignia. Whereas you see in this situation, I'm in my bedroom, so you see, things going in the background, and I make an effort to make sure everything's clean, but you never know. My dog is coming in and out, the dog barks, these kinds of things. That takes away from the solemnity of proceedings. So I'm concerned about that, and you have to worry about that. And also the emotional aspect of a court hearing. A lot of people want their day in court, right? And so I was concerned about that, but I was surprised actually the other day when I did a mediation. It dealt with a fatality claim. So certain times of the hearing that it was quite emotional. This woman had been hit by a car and killed. And it was the same. It was interesting. It was the same. They were able to express their concerns, and there was a certain emotional aspect to that mediation that I was concerned you wouldn't have like you do in a courtroom or our normal JDR meeting rooms. And of course, we are concerned about the public and access to hearings, and something that we're still working on. For instance, I had a very large commercial matter last week. It made the newspapers and several articles. It's a huge diamond mine that has gone into insolvency in the north. Only the parties to the actual application were on the hearing. Of course, everything was filed, and the press picked up on it and was able to report on that hearing based on all of the written material that was filed in court. But I do worry that, normally the press, quite frankly, don't show up in commercial matters because they're kind of not that fascinating. It's not like a murder trial or something. But nonetheless, it's not as public as it could be. We've made some efforts in our criminal matter hearings. So we've had some sentencings and convictions that have happened remotely, and the press has been invited into the actual hearing. So that way we're accessing the public, but it isn't the public. I do know that in other jurisdictions, like in Texas and Florida, they are using YouTube. So they are live streaming all of their hearings so that the public can be completely involved. We haven't got to that stage yet, but if the matter continued, that's something that I'm sure the criminal committee is in particular is looking at to make sure that public access to these hearings is maintained.
Right. Well, a follow-up to you, Chris, on that. Assuming that at some point we start to go back to some form of normal. I think a lot of us are calling it the new normal that we might be going back to. It sounds to me that you see clear lessons that will be learned from this time in terms of how we resolve disputes in the future. And what has this experiment, if you will, taught you about remote working in the court?
Well, firstly, I don't think that we will ever go back, and I hope that we never will go back to where we were at in the completely traditional, in-person, paper-based cases. We've learned a lot, and I think that it's been it's been almost a tipping point, to use Malcolm Gladwell's comments, but I think it's a tipping point that really the judges, the profession, the public have learned a lesson of how we can manage using technology a lot more. Overall, it decreases costs a huge amount if it's used properly to the public to attend. So for instance, when we're in Grand Prairie, we have people driving in for 1 or 2 hours on very dangerous roads in the middle of the winter. Those people can attend by their computer. And these kinds of things I think will be really interesting, and hopefully will be lessons that we will be able to apply to really open up access to justice and reduce the costs in the future. So I'm quite positive about that. And e-filing, as Charlene indicated, is on its way now. Some of the things that were blocking change seem to have miraculously disappeared, and I'm hoping that we will be able to really move forward on a lot of the things that we've had to move forward on because of the crisis, but later for more basic reasons of access to justice. And, that kind of thing.
Great. Well, finally, for both of you, remote working, working at home is a challenge for many of us, and of course, we're all differently positioned in terms of those challenges. So, as a final question to both of you, do you have any advice, any words of judicial wisdom to those of us who are trying to manage these new ways of working in these difficult times? Who wants to go first?
Sure.
Well, I would say patience and keeping an open mind. So patience, tell yourself you can learn the technology. I'm not very technologically savvy, and yet I am coming along. I'm surprised at how quickly I've come along. So I may have been one of those judges that Chris was complaining, that Justice Eidsvik was complaining about earlier.
And Chris, your final words of wisdom.
I agree that patience is the number one thing. One of the things I think has changed is that people realize now that technology is not perfect. And these hearings, it's not perfect. And it's not certainly perhaps as optimal as it was when you're seeing somebody face to face. But I sense a sense of a lot more effort to be patient about technology. Whereas in the past, if things went wrong, people would just say, well, that's it. I'm out of here. I'm not trying this thing. I'm going to just use what I'm used to. And so I think that open-mindedness to new situations and coming up with new solutions for problems. Like one of the things that's happened recently is judges were concerned that in mediations, and of course everything doesn't always work 100%, so you need to have access to each other. So people are concerned about giving out their telephone numbers. They don't want to have their private telephone numbers given out. But there are, I found out, because I didn't know, that you can get these apps where you can get a burner telephone number that will work, and then you can disable that telephone number. Who knew about that solution? Who knew that it was even an issue? And so it's this kind of thing that is really tremendous, that instead of just saying, no, it won't work, people are really working hard towards getting solutions and being a lot more accommodating about the fact that things are not perfect, and everybody is in the same boat in terms of trying things out and goofing up and not always being the whiz technologically, because nobody really is. And so we're all in the same boat of learning and trying to make things work, which is awesome. It's very exciting.
Well, Madam Justice Eidsvik and Madam Justice Anderson, I want to thank you both very much for joining us remotely at the Institute of Advanced Legal Studies. And on behalf of our audience and myself, I want to wish you all the best with these judicial ways of work. Thank you very much.
Thank you.
It's been really fun.